the application for condonation in respect of the late institution of the application for leave to appeal. Your Worship knows that the test that should be applied in cases such as this is that there should be an explanation for the delay, there should be a measure of prospects of success, and there should be a consideration of prejudice. Of course, none of these considerations individually is decisive. They all constitute part and parcel of an overall assessment. And the Worship is empowered to grant condonation under Section 309, subsection 2 of the Criminal Procedure Act. Now, in terms of the notice of motion, we ask for condonation in respect of the late filing of the application for leave to appeal. We ask for condonation in respect of any other aspects that we may not have complied with. In relation to the explanation for the delay, Your Worship knows that initially there was an application brought in February 2018. And that application appears from page 20 of the papers before Your Worship. And the explanation is we were unaware as to the destination of that application. It became clear only when we brought proceedings before the High Court, which were held on the 1st of October 2019, that that application was in fact either not pressed with or abandoned at the hearing. Only at that point did we then see that actually the correct procedure is that you should come to Your Worship and bring an application for leave to appeal in respect of condonation. That application was then brought on the 9th of October 2019. It contains at the beginning, in the first 3 pages, a section on condonation, and it explains the delay from the 4th of December 2017, and then it ends with the explanation in 2018. But as Your Worship pointed out, that is not a proper substantive application for condonation, because we always needed to put in a notice of motion supported by an affidavit. So that defect has now been fully cured. We have now a notice of motion, and we have a founding affidavit signed by Mr. State, who is the attorney for Mr. Cekeshe. The story is taken by Mr. State from the time when the conviction was confirmed by this court. And Mr. State explains that throughout that period, there were previous attorneys, and he got onto the record in December of 2018. He then explains the steps that he took right up to May 2019 in respect of the compilation or the reconstruction of the record. Because as he correctly observes, it was impossible to give any meaningful advice to Mr. Cekeshe in the absence of a clear sense of what the case was about and what had in fact transpired. Once those proceedings were exhausted, an application for leave to appeal was instituted in the High Court. And that application was brought on the basis, it turns out later, of the incorrect understanding of the facts, that in fact Your Worship had not dealt with the application for leave to appeal in relation to conviction. When that matter then came to our attention, we then brought a full application together with a full explanation in relation to the issue of the conviction. So we would submit with respect, there is a full explanation, it's given under oath, and there is nothing bona fide in the explanation. It's brought bona fide, and it does not hide any aspects, and it's in good faith application drawn by the attorney for Mr. Cekeshe. Your Worship then has to consider the question of the prospects of success. I don't have to go through the prospects of success. They constituted the substantial bit of the case that was heard by Your Lordship last week, and Your Worship knows that the gist of the case that is brought by Mr. Cekeshe relates to whether the procedure prescribed by Section 112 sub 2 was complied with before the conviction was confirmed. He simply argues that there is a reasonable prospect that another court may arrive at a different conclusion in relation to that issue. That then takes me to the last issue that Your Lordship will have to consider in relation to condonation, which is the question of prejudice. We do not see that there is any prejudice, certainly no child prejudice, that can be suffered by the state, and there can be no child prejudice in relation to the general administration of justice. Certainly, when the application for leave to appeal was instituted on the 9th of October 2019, together with a condonation section, no prejudice was pointed by the state. And we do not see that there would be any adverse impact on the administration of justice. In fact, the indications are the other way around. It seems that there would be manifest prejudice to Mr. Cekeshe if the application for condonation for the late institution of the application for leave to appeal is refused, because the impact on him is that the matter would then be decided on a technicality of the highest degree, and that the matter would not be decided on the merits of the case. If Mr. Cekeshe has a good case, he is entitled to have that case properly ventilated and properly decided. What would be unfortunate is that he will be prevented from ventilating the case on the merits on the basis of condonation. The last point on the question of prejudice is that it's not actually Mr. Cekeshe who is to blame for any of the issues that have arisen here. The blame, if any, is to be attributed to the previous representatives and the subsequent attempts that were made by Mr. Steyn to try and reconstruct the record in order to give meaningful advice. Again, that too is not a matter that can be attributed in any way whatsoever to Mr. Cekeshe as an incarcerated person, and particularly one incarcerated in the circumstances under which he was, where he has no access to resources on his own. This is not the type of delay that could be blamed at the door of Mr. Cekeshe. If anything, there is two sources for the delay. The one is that there is no explanation from the previous attorneys about what steps they took as soon as the leave to appeal on sentence was refused. And there seems to also to have been a failure of the system, in the sense that even until last week, we were just unaware that even your Lordship's judgment in relation to sentence existed. And despite numerous attempts, even my then friend for the state didn't know about the existence of these records. So it seems that it's partly a question of the failure of the system on the administrative side, not on the judicial side, and also partly a failure of the legal representation that Mr. Cekeshe has received up to so far. None of those should count against Mr. Cekeshe in any manner whatsoever. So I would submit to your Lordship that we have made out a good case for condonation of the late filing of the leave to appeal under Section 309B of the Criminal Procedural Act. And if it pleases your Worship, you may condone the late filing, and your Worship may then proceed indeed to deliver the judgment in relation to the matter that was set down last week. As your Lordship pleases.
Your Worship, I'm not going to be that long with around last week. However, this is only about the application for condonation for late filing and for application for the PSP. I have addressed this issue in my head's argument, paragraph 6, from paragraph 6 to paragraph 10. Still appeal to my argument today, what I have stated there. And it also appears this issue related to the late filing of sister contention to appeal. Also appear in the answering affidavit, which was also in last week, from paragraph 10 to paragraph 11. What I find it really difficult to understand about it, there was a still of the new legal team for the applicant didn't have the record. However, they are now appealing against conviction. They have already filed a petition. It's something that I could not understand, that the petition relating to this conviction. One, then asked himself about the question of whether they have the transcript of the record regarding a judgment on the conviction, but it looks like that part of the record was there. But the notice would have been dropped immediately. I understand that they indicated that they were instructed or appointed in December 2018. What happened in December? What happened in January, early in the year, 2019? Even when one look at the paragraph 56, which is on page 16 to 18, where there is this communication between which the medical team and the company with the transcription. When one looked at it, it looks like there was communication until April, which indicates that it says to me probably that in April the record was there, because there's no complaint after that regarding the record regarding to the judgment on the after a plea of guilty. It looks like the record was there when I did the papers, and that they could file a notice of invitation to application for condemnation for the filing of notice of invitation to appeal against conviction. When one counts how many months after they were appointed or instructed by the applicant, Mr. Cekeshe, in this matter, it's almost, I would say, 10 months. But the condemnation is brought in now in October, September, October, and it's not brought into this court. In September, last taken to High Court. In October, was brought here to this court. Understand about the affidavit which was made today by the instructing agreement, the reason for the delay and also the argument that Mr. Cekeshe should not be blamed for it. But the legal representation is the one that knows the rules of the court, and they should comply with the rules of the court. Not that they decide later that they will do it at their own time. And even application formally apply for condemnation before they even apply for actually apply for leave to appeal. My submission is that the application, the explanation by the applicant in this matter for condemnation should be refused. If not, my submission. Based on the elements that are mentioned in both documents, my department and Asari affidavits, and what I've just stated, and the state still submit that there is no prospect of success in this matter, accused with committing this act. Lastly, if that the condemnation is dismissed, application for the plea is also dismissed, I don't think there will be any prejudice. I can still submit. Yes, the accused can say the prejudice would be that it still remains in custody, but because he was sentenced by this court. However, the legal team will know the legal procedure, what they should do. And now we are talking about the rules which the legal team should comply with, and the legal team will comply with itself. But now, other people have been blamed for that who were the legal team previously. They did not do a good job. But none of them, the current legal representation, has not been blamed for not bringing this application right from the beginning, before you even argue for the application for the judgment against conviction. The condemnation was supposed to be the first and first that you cross that bridge before you can go to the application for conviction. Condemnation was supposed to be the first application or argument which should have had in this matter. I still submit that there's no one else who of the new legal team is not blamed for anything except all those who were in this matter before we came into this case. But I think we should also take the responsibility that they did not file an application for condemnation and even immediately after the instruction they obtained from Mr. Cekeshe, which I think one would have maybe have condoned them and accept that they have properly complied with the rules. But they didn't do it. How they blame the previous legal representative who didn't have any instruction from last year, December 2018 until now. My submission is that all these applications should just be dismissed. And there's something which is interesting here, which I also saw in the documents. I just read them. It's talking about costs, paragraph number 3 in the first page of this application for condemnation, which says that majority to record that such party opposing this application pays the cost of this application. But in a criminal court, maybe with my experience, I've been in this court for quite some time, I've never heard of the criminal court that we have to, criminal cases, we have to pay the cost to oppose the application. If we must accept everything, or the prosecutor should not oppose any application by the defense in the criminal court. So, because we'll be scared of this, that we have to pay cost. But I'm saying that I don't think it's actually relevant in this criminal court. The application should be dismissed.
With respect, it does not appear that our learned friend has familiarized himself with this application, because for the most part, what he argues is not covered in the application is in fact covered. First, he says that there is no explanation about why this application is being brought now. At paragraph 12, page 6, Mr. State explains, on 15 January 2018, the applicant's erstwhile attorneys filed with this honorable court an application for leave to appeal in terms of section 309B of the CPA, wherein he applied for leave to appeal against both his conviction and his sentence. A copy of the application is attached here to mark A1. The applicant applied for condonation for the late filing of this application for leave to appeal. On 15 February 2018, this honorable court and magistrate's customs granted condonation for the late filing of the application for leave to appeal. The applicant assumed that this condonation related to both his conviction and sentence. So this is explicitly stated in the founding affidavit that there was initially an application for condonation. There was also an application for leave to appeal in respect of conviction as well as sentence. And then he explains in paragraph 17, the following page. That's why it actually helps to read the papers before you say things are not covered. In paragraph 17, he then says, it was only during very late discussions with the respondent and during argument in court. And I am actually astonished at what my learned friend is saying. It was him who brought it to my attention on the 1st of October 2019, when we were both in the High Court, that in fact that application in relation to conviction had not been persisted. But nevertheless, the deponent specifically says it was only during very late discussions with the respondent and during argument in court on 9 October 2019 that the applicant came to realize that his initial application for leave to appeal his conviction, which was argued on 15 February 2018, had either been abandoned by his previous attorneys or that same was simply not argued by such attorneys. Now, both of those paragraphs are quite clear that there was an application which my attorney had cited. The rest of the time, they have been trying to get hold of the record of the proceedings. But they assumed that that application related to both conviction and sentence. This is why the petition that is before the High Court attacks both the conviction and the sentence. It was only when my learned friend pointed out to us that the issue of the conviction has not yet been dealt with, which is understandable in the context where the records are simply incomplete and the transcript is simply unavailable. But as soon as that issue was brought to our attention, the proper application for leave to appeal in relation to conviction was then brought. So far from the affidavit not addressing the two issues that my learned friend complains about, it explicitly addresses both of them. The next thing that my learned friend talks about, he says that the record was available. I mean, this is the most astonishing submission. Last week, your Lordship remembers my learned friend complaining precisely where he is sitting, that the record is incomplete and contains parts that have been left out, which include submissions that he made. Your Lordship was here when my learned friend admitted that he himself did not even know about the proceedings on the 4th of December 2017, illustrating again the incomplete nature of the record. How he now suggests in a rather opportunistic fashion that the record was always available is actually an astonishing submission. The fourth issue that he talks about is that why is the current attorney not taking the blame? And why is he attributing the blame to the previous attorney? Well, that argument was held last week already in full about the glaring errors that were committed by the previous legal representatives. Insofar as the current attorney is concerned, he has actually given a full account of each and every step that he took to make sure the case is properly brought before the court. So the idea that he should somehow be blamed in the air is rather a rich idea coming from the state. The fifth point relates to prejudice. My learned friend cannot point to any prejudice that the state will suffer. And yet, the prejudice that Mr. Cekeshe will suffer, he himself, my learned friend, acknowledges that what it means are two things. Firstly, he remains in custody and incarceration. But secondly, which is the prejudice that I pointed to your Lordship, the prejudice is that he is unable to have his case ventilated on the merits because it can be blocked on a technicality. That type of prejudice is the sort of prejudice that the state is simply unable to overcome. If I can illustrate to your Lordship that if it is refused purely on condonation, in circumstances, your Lordship, you remember last week when we argued the matter, it is not the state that persisted with the condonation issue at all. The issue arises from your Lordship's wise counsel, I must add, to us, that the correct procedure is that we must first get condonation before we can debate the Section 309B issue, not from the state whatsoever. If this issue was so prejudicial to the state as it is now made out to be, and in our respectful submission, rather opportunistic, if it was so prejudicial, there is no doubt that last week they would have dwelled on the question of prejudice. The mere fact that they are hanging on to prejudice simply as a consequence of your Lordship's reminder that there is an outstanding step that has not yet been covered simply shows that there is in fact no prejudice that will be suffered by the state. Even if there were to be prejudice to be suffered by the state, the real function of a court is to weigh the respective prejudice between the state and my client. When one weighs the prejudice between the state and my client, it seems there is just no contest that it is my client that will suffer the greater burden of prejudice. And in those circumstances, it would be manifestly unjust that my client would be refused the opportunity to argue the case and to ventilate it on the merits on a technical basis where the state is unable to point to any substantial harm that will be suffered in the administration of justice. So we would submit with the greatest of respect that the opposition, just like the opposition to bail and just like the opposition to leave to appeal, is utterly contrived.
dealing with the issues in question, I believe that it is necessary to summarize the build-up to the current applications. The applicant and another suspect were arrested on the 26th of October 2016 and charged with public violence, assault with intent to do grievous bodily harm, and malicious injury to property. They appeared in court for the first time on the 28th of October 2016. On 2 November 2016, the applicant was released on bail. On 27 June 2017, after disclosure of the police docket was made to the defense, the applicant's attorney, Ms. Mbata, placed on the record that the applicant intends to plead guilty to the charges. On 21 September 2017, the applicant indeed pleaded guilty to and was convicted on charges of public violence and malicious injury to property. The case against his co-accused was separated from his trial and referred to another court for trial. On 4 December 2017, the court, having taken the two counts together for purposes of sentence, sentenced the applicant to 8 years imprisonment, of which 3 years were conditionally suspended for 5 years. On 15 February 2018, the court dismissed an application for leave to appeal against sentence. On 11 September 2019, an application was made to the High Court for bail pending appeal. The parties, however, agreed to rather approach the trial court with the application for bail. A petition for leave to appeal against both conviction and sentence was instituted in the High Court on 18 September 2019. On 9 October 2019, the case, that is last week, the case was, without my knowledge, enrolled for an application for leave to appeal against conviction and an application for bail pending a petition to the Judge President of the Gauteng Local Division of the High Court. No notice was given to me of the intended applications, and no founding affidavits or heads of argument of the parties were handed to me in order to prepare for the applications. Bundles of documents were handed up to court while the respective legal representatives argued the matter. I will now turn to the applications, starting with the application for leave to appeal against conviction. In terms of Section 309, capital B, 1A, read with subsection B, Roman 1 of the Criminal Procedure Act 51 of 1977, hereafter referred to as the Act, further read with Rule 67(1) of the Magistrates Courts Act 32 of 1944, any accused who wishes to note an appeal against conviction or sentence or order of a lower court must apply to the trial court for leave to appeal within 14 days after the passing of the sentence. The applicant failed to comply with that provision because it is now 22 months after sentence was passed. In terms of subsection B, Roman 2 of the Act, the trial court may condone a late application if good cause is shown. The subsection is clear that condonation can only be considered upon an application. In applying for condonation, the applicant relied on an affidavit deposed to by his attorney, Mr. Stell. Mr. Stell described the logistical challenges he had to consult with the applicant in prison and his frustration in obtaining a transcript of the court record since he was instructed in December of 2018. He still does not have a complete transcript of the record. He also labored under the belief that since the court granted the applicant condonation for the late filing of his application for leave to appeal against sentence, the condonation extended to the present application. That was, however, a wrong belief and has since been cured. Counsel for the State has opposed the condemnation application. When an application for condemnation is considered, the court has to exercise a judicial discretion upon a consideration of all the relevant facts. It is trite law that good or sufficient cause has two requirements. The first is that the appellant or applicant must furnish a satisfactory and acceptable explanation for the delay. Secondly, he must show that he has prospects of success on the merits of the appeal. Having regard to the contents of Mr. Stell's affidavit, the court is satisfied that the applicant has shown good cause for his late application and is granted condemnation. Advocate Kukatobi attacked the conviction of the applicant on the following grounds. 1. The state failed to disclose video footage to the defense before the trial started and tricked the applicant into believing that he was identified on video footage recorded at the crime scene. 2. There are discrepancies between the allegations in the charge sheet and the admissions made by the applicant in the statement drafted in terms of Section 112(2) of the Act by his erstwhile legal representative. Furthermore, the applicant did not admit all the allegations in the charge sheet, and the admissions contained in the statement were ambiguous. Thirdly, the court erred in not questioning the applicant in terms of Section 112(1)(b) of the Act. Fourthly, the applicant did not have a fair trial because counsel representing him at the time was inexperienced and incompetent. Advocate Mochibe, on behalf of the state, opposed the application for leave to appeal against conviction. He stated that the video footage was shown to the defense on at least 2 occasions, once at his office and once at court. In his reply, Advocate Kukatobi did not dispute it. The issue of possible video footage was known to the applicant from the outset. At his first appearance in court, State Counsel applied for a postponement of the proceedings in terms of Section 56(d) of the Act in order to verify the personal particulars of the 2 accused and to obtain video footage of the incident before starting with the bail application. When disclosure of the police docket was made to the defense, State Counsel mentioned that he will give the defense a disc with the video footage. At no stage up to now did the defense complain that they were not furnished with a copy of the video footage. After reading into record the contents of the Section 112 statement, Advocate Ramahili, who represented the applicant at the time, wanted to hand up to the court photos that, according to him, emanated from the video footage that was taken. In his address in mitigation of sentence, he stated that it was unfortunate that the applicant was seen in the video footage. It is highly unlikely that the defense would not have had sight of the video footage before tendering a guilty plea. This was not a matter where the applicant was caught red-handed. He was arrested a day after the incident. Asked by the court why the applicant pleaded guilty, the probation officer, Ms. Nkosi, stated that he was identified on the video footage. All of the above is indicative that the video footage was disclosed to the defense before the applicant pleaded. The claim that the video footage was not disclosed to the defense is devoid of all truth. Submitting that there are discrepancies between the allegations in the charge sheet and the admissions made by the applicant in the Section 112 statement, that the applicant did not admit all the allegations in the charge sheet, and that the admissions made in the said statement were ambiguous, Advocate Kukatobi raised a number of opportunistic arguments. One was that in respect of the public violence charge, the applicant referred to the conduct of the crowd in general and that he did not admit his individual actions. The law in this regard is clear. Once it is established that a person knowingly took part in a disturbance which had as its aim the endangering of public peace or security, it is unnecessary to prove specifically what particular act of violence was committed by him or by each of the individual participants. The ordinary principles relating to the application of the doctrine of common purpose also apply to this crime. In drafting the charge, the state alleged that the accused and others assembled with common intent to disturb the public peace or security and acted in concert when throwing bricks at a police vehicle and blocking the roads with bricks. In paragraph 5.1 of the section 112 statement, the applicant admitted that he and others assembled with a common intent to disturb the public peace or security by blocking the road with bricks and tree branches. In paragraph 8, he went a step further by admitting his individual conduct of obstructing the road by placing bricks and tree branches on the road. He added that when the group saw the police vehicle, one person threw a brick at it, and once the occupants alighted from the vehicle, they continued to throw stones. In respect of the malicious injury to property charge, it was submitted that the applicant did not admit that he set alight the police vehicle and did not injure any police officer. The state alleged that the applicant broke and or damaged and or set fire to a police vehicle with the intent to injure two constables and or SAPS in their property. Defence counsel must have misunderstood the reference to injury in the charge sheet because the state never alleged that the applicant injured any police officer. If that was the case, the applicant would in all likelihood have been charged with a further offence of attempted murder or assault with intent to do grievous bodily harm. The meaning of the word injury in the definition of the defence is a synonym for the word damage. In paragraph 5.1 of the section 112 statement, the applicant admitted that he damaged and set fire to a police vehicle in the possession of the two constables with the intent to injure and damage the said vehicle. In paragraph 8, he admitted that he went to fetch paraffin and matches and set the vehicle alight. In paragraphs 9 and 10, he repeated that he damaged the vehicle by burning it. After his counsel read the statement into record, the applicant confirmed the contents thereof. As far as the court is concerned, it is crystal clear that the applicant admitted all the relevant allegations in the charge sheet. There are no discrepancies between the allegations in the charge sheet and the admissions made by the applicant, and none of the admissions are ambiguous. When interviewed by Ms. Nkosi, the applicant reiterated that he stoned the police vehicle and doused it with paraffin and lit it up with matches. Insofar as the admissions made by the applicant are concerned, there is no merit in any of the arguments put forward by defence counsel. Citing case law, Advocate Kukatobi had submitted that even if a statement is handed up to court in terms of section 112.2 of the Act, there is still a duty in terms of section 112.1b on the presiding officer to question an accused who pleads guilty in order to ascertain whether he admits the allegations in the charge to which he has pleaded guilty. Section 112(2) of the Act provides for the procedure to be followed by a presiding officer once an accused pleads guilty to an offence and has drafted a statement in which he sets out the facts which are admitted. It reads as follows. If an accused or his legal representative hands a written statement by the accused into court in which the accused sets out the facts which he admits and on which he has pleaded guilty, the court may, in lieu of questioning the accused under subsection 1B, convict the accused on the strength of such statement and sentence him as provided in the said subsection if the court is satisfied that the accused is guilty of the offence to which he has pleaded guilty, provided the court may in its discretion put any question to the accused in order to clarify any matter raised in the statement. The submission of defence counsel is unconvincing and does not hold water. The facts of the cases he referred to are distinguishable from the facts of the present matter, and none of the cases support his argument. The ordinary meaning of the word lieu is in the place of or instead. Simply speaking, it means that instead of questioning the accused, the court may admit a statement on his behalf. The whole purpose of section 112(2) is to dispense with the questioning of the accused once a statement has been handed up to court, provided that the court is satisfied that the accused is guilty of the offence to which he has pleaded guilty. If the legislature wanted the court to always question an accused who has handed up a statement, it would have worded the section differently. To question each and every accused who hands up a statement would make section 112(2) redundant. In the statement, the applicant stated in no uncertain terms that he understood the charges, that he understood the implications of this statement, that he is aware that he may be convicted on the strength of the statement without any witnesses being called, that at all material times he had the necessary intention to commit the crimes, that he knew that his actions were wrongful, unlawful, and punishable by law, and that he does not have a valid defence in law to excuse his action. He further admitted each and every allegation in the charge sheet, as well as the elements of the two offences. Except for raising the issue of a possible splitting of charges with the respective legal representatives, there was in law no need for the court to clarify any matter raised in the statement. This brings me to the last point taken by Defence Counsel regarding the alleged incompetency of the applicant's legal representative. The general rule is that a litigant is bound by what is done by his legal representative. At no stage during the trial or application for leave to appeal against sentence did the applicant hint that he was not satisfied with the conduct of Advocate Ramahili. The applicant is not an immature or unsophisticated or uneducated man. To the contrary, after matriculating, he started studying law, but subsequently changed to media studies. He had more than enough time during the trial and application for leave to appeal against sentence to raise any objection to the manner in which his trial was conducted, if he had any. The fact that he briefed the very same advocate to apply for leave to appeal against sentence indicates that he had trust in his competency. In S v. Bennett, 1994, Volume 1, SACR 392C, it was held that where an accused has not taken any steps to withdraw his counsel's mandate and expressed no disagreement with the conduct of his case until after the verdict had been given, he is not entitled to challenge the correctness of the verdict on appeal on the ground that his counsel had been negligent in the conduct of his defense. The contention that the applicant did not have a fair trial because of the incompetency of his legal representative is unfounded. The applicant bears the onus of satisfying the court on a balance of probabilities that he has a reasonable prospect of success on appeal. He has failed to discharge the onus that rests on him, and in the result, the application for leave to appeal against conviction is dismissed. Finally, I will deal with the application for bail pending a petition to the Judge President. In applying for bail, the applicant relies on an affidavit opposed by his attorney, Mr. Stale. In opposing the application, counsel for the state argued that the applicant cannot rely on the affidavit, but that he himself should have deposed to an affidavit. That argument is without merit. There is no prohibition in the South African law for an accused who applies for bail to rely on another person's affidavit. In S v. Rabat, 1999, Volume 2, SACR 398 WLD, it was held that when an accused who has been convicted and sentenced to imprisonment seeks bail pending an appeal against his sentence only, the prospects of success of the appeal is an important factor. The test to be applied is not whether the appeal will succeed, but whether the appeal is free from predictable failure. In the event of the appeal having no prospect of success, so that bail would entail a postponement, but not the avoidance of imprisonment, bail should not be granted. The applicant has already been denied leave to appeal against sentence. He has now also been denied leave to appeal against his conviction. There is no reasonable prospect that the applicant will avoid imprisonment, and it is therefore not in the interest of justice to grant him bail. It is not in the interest of justice that a convicted person pursuing a hopeless appeal should be released on bail. The application for bail is likewise dismissed.
Judgment so that it attaches to the application to the High Court.
It's not immediately available since I've had some technical problems with my computer. And the registry on earlier today for Mr. Stale to compile the application for consideration, but it should be available within a couple of days.
Call me on this number. Let me give it to you now. What's the number?
776.
All right. Hi guys. Yeah, call me on this number quickly. 076 298 2944. Oh, sorry, 2499. Yeah, 076 298 2499. Call me urgently, as in now, guys. Sure.
I think it's fine, guys. Let's leave it. Let's leave it. It's fine.
Hello? Yeah. Yeah, sizawuthetha nobhuti ngoku. Yeah, ngizawuthetha nobhuti ngoku. Okay, just give it a press. Hello?